Hi, my name is Greg Fitzgerald. I am a California attorney. I've been practicing debtor protection for 22 years, and our firm, Fitzgerald and Campbell, has what we refer to as a debtor protection settlement plan. By way of overview, what this plan does, number one, is it puts a wall between you and your creditors. Your creditors can no longer call you, contact you, mail you, email you, call your work, any of those things, once they are aware that we are your lawyer. So we put up a wall. You no longer have any direct communications with your creditors, and if they do, that's a violation of the law. I'll talk about that in just a second. The next thing that we do is we demand from the creditors that they prove up what you owe, if anything. This is referred to as verification of the debt or validation of the debt, any other number of names. But essentially what it is we compel or we insist that they establish what amount you owe, if any. In the meantime, all collection activity must cease. That's by law. And if they continue to collect, obviously that's a violation of the law. And again, I'll talk to you about that in a second. But the second thing that we do, remember, the first thing is the wall. The second thing is insisting that they prove, essentially, what it is that you owe. Don't be surprised in the meantime that they'll violate the law. They will contact you even though they shouldn't. If they do, we will protect you. We will make a claim against them for that. As you may be aware, improper contact to you, which is a contact to you anytime after you're represented by a lawyer. Not just after 9 o'clock or before 8 a.m. and not just for foul language. Any sort of call. If they call you and say, "Good morning, Mr. Jones, don't want to bother you, but when can you pay us?" Not otherwise a violation, but when you're represented by a lawyer, that's a violation. They should not be contacting you when you have a lawyer. We watch out for those violations. So we put the wall up, we insist they prove the debt, we watch for any violations that they're going to commit during that time. Until they can prove up something, we don't recommend that you pay them any amounts of money. Our plan is flexible. It's specific to you. It's customized to you for what your circumstances are. It depends on what debts you have, what debts it is that you need to take care of, and can change. If today bankruptcy is not an option for you, but next year it looks as though it may be the only option for you, then we can go in from our debtor protection settlement plan into a bankruptcy filing. So the flexibility is a key component. The last component that's very important is the money. We do not hold your money. Several companies, lawyers insist that you forward them set amount of money every month, that you build up this reserve. We don't recommend that you do that. We recommend that you hold on to your own money. If you're not able to do that well, have somebody else hold on to your money other than some company or somebody that you don't know in some state you don't know where the money's at. Very difficult to get your money back once you give it to somebody, even if it is supposedly your representative. So we don't hold your money. We don't take your money, and we don't recommend that you give your money to anybody else. Remember, our plan, our overall goal is to keep as much money in your pocket as possible. Our fees are affordable in our plan. Depends on the type of debt that you have in terms of what our fees might be, but you'll see that our fees are extremely affordable. Our consultations are free. I encourage you to give us a call, encourage you to look at our website, give us an email, ask any questions that you got. We're here to help you out as best we can. I look forward to talking to you, and thank you for watching this video.